A will or a last will and testament is a legal document that sets out how a person's assets will be distributed after his or her death. The reading of a will is likely one of the legal proceedings most familiar to non-legal audiences. The movies have left us scores of them, often involving members of a feuding family sitting around a library fireplace of an imposing mansion, while an attorney stiffly reads a gasp-inducing scroll of parchment. As with most things in the legal world, the movie version doesn't quite measure up to reality. Having a will is important for protecting your wishes, and there are some critical things to understand about them. But they don't need to be thought of as intimidating, and may be an opportunity to avoid the expense of hiring an attorney. First, let's take a look at why wills are important. Assets have to go somewhere after a person dies, and as the saying goes, you can't take it with you. Without a will, your assets will pass on to your next of kin in a manner prescribed by the state where you live. If you don't have any surviving family, your assets will escheat, which goes to the state itself. Neither of these options is likely to reflect what the person who died really wanted to happen. What if you want a certain painting to go to someone who is not related to you, but who often expressed admiration of it? Or what if you are passionate about a certain charitable cause and want to leave something for it? Without a will, these things are unlikely to happen. This leads to the second major reason wills are important: avoiding disputes. Without a written document setting out the estate owner's last wishes, it's easy for different people to feel that they've been promised the same thing by the deceased. Disputes like these can easily progress into litigation, the resolution of which often notoriously consumes part or even all of the decedent's assets. Now let's take a look at the basic terminology and structure of a will. The person who is passing on his or her assets is called the testator. The people who receive something under the terms of a will are called beneficiaries. And the sum of the assets of the person who is passing on is called the estate. Before you create a will, it's a good idea to document all assets you will be able to pass down. Next, you'll want to choose an executor. This is the person responsible for making sure each beneficiary gets the assets you intend, a process sometimes called distribution. The executor can be an attorney, but doesn't have to be. If you have children who aren't yet 18, you'll also need to appoint a guardian who will look out for them and steward any assets that they receive under the will until they become adults. With these in place, you are ready to choose who will get what. Once your will has been written down, it's important to strictly follow the signing requirements for the state where you live. This step leads to a surprising amount of controversy with wills. Most states require that the testator sign the will in the presence of 2 witnesses, who then have to sign the will themselves. But check our website for a table with a complete list of requirement laws for every state. Once it is signed, and if your state requires it, notarized, the last step is to keep your will someplace safe. For someone with a relatively simple estate, it may be possible to follow these steps and create your own will using one of the many sample forms found on our website. But let's take a quick look at situations in which it may be advisable to seek the help of an attorney. These present complex legal issues that may be best handled with the assistance of an expert. They include passing on the ownership of a large business, passing on real estate located in multiple states, assets that may be covered by pre-existing legal documents such as a prenuptial agreement, assets with disputed tax liabilities, the appointment of a guardian for a child that is disputed by someone with joint custody with the child, such as a divorced spouse. We're eForms, the largest online database of legal forms and documents. Click the link to learn more about wills, including the difference between wills and trusts, and to find relevant laws and sample documents for every state.